Samadhan Samaroh is a new name that the chief has given for what is popularly known as mediation. Main problem is about large pendency of cases, and the second issue, which is not about pendency, is the method by which disputes can be resolved easily, comfortably, without too much of a technical procedure. The essence of this resolution is informality. That's the big distinction between a court cases and resolution. The law has evolved, and that particular agreement that they arrive at is now given the sanctity of law, and that agreement will be in the nature of a decree of a court, which can really be enforced. So it is given the tenor of an enforceable document. So agreements which are arrived at on the basis of a mediation and in Lok Adalats are enforceable documents. So they can straight away be executed.
The Supreme Court of India has undertaken the Samadhan Samaroh initiative. It aims at facilitating the settlement of cases pending before the Supreme Court of India amicably through consent-based resolution mechanisms. This initiative started on 21st April and will be concluding with a special Lok Adalat from 21st to 23rd of this month. To talk more about this, we have with us Honorable Justice P.S. Narasimha, Supreme Court Judge. Sir, welcome to the program.
Thank you. Thank you for having me here.
So let's begin by understanding more about Samadhan Samaroh initiative and what problem in the judicial system is it trying to address?
The main problem is about large pendency of cases, and the second issue, which is not about pendency, is the method by which disputes can be resolved easily, comfortably, without too much of a technical procedure. These are the two things that we are seeking to resolve through Samadhan Samaroh.
So if you can tell us a little more about what Samadhan Samaroh is and how is it different from a regular court?
Yeah, Samadhan Samaroh is a new name that the chief has given for what is popularly known as mediation. You know, the fundamental difference between mediation and a regular court hearing lies in the empowerment of the persons who are seeking justice or a resolution. In a mediation, the persons who are litigating before the court are given the power to decide the dispute. They are given the atmosphere, they are also given the method by which they could give and take, and eventually the resolution occurs through their own decision and not by an independent body like that of a judge who, irrespective of the likes and dislikes of a party, will finally decide. The advantage of a mediation is that the resolution is arrived through a voluntary process of those who are involved in it. That's the greatest advantage of resolution as against a decision making by a court of law. It's far more enduring, it's far more satisfying that a resolution is brought about by their own intentional and deliberate decision making. That's the fundamental difference.
Right. So if we're talking about this process, it started around 4 months back and it will be concluding with a special Lok Adalat. There have been various stakeholders, whether we talk about advocate on record, district service legal authorities, banks. So can you give us an overview about the entire process and how is it actually getting implemented on the ground?
Yes, we have been undertaking this what we call an adversarial litigation system, where you have advocates for each of the rival parties and a judge to decide. This was there from even before independence. We have now begun to accept this concept of mediation, and it has been successfully undertaken for a very long time, but we have not really institutionalized it. and we have now a Mediation Act also. So far as the Supreme Court is concerned, we have been holding Lok Adalats from time to time, but now with the advent of some kind of a professionalism in conducting mediation process, we had started 2024 in a big way. What we had done at that time was we contacted the litigants living in the even in talukas through the NALSA, National Legal Services Mechanism. So we reached out to them, the courts reached out to where they were living, and both the parties, there was a platform arranged for them to come together, and mediators at that stage, at that place, brought them together, made them discuss with each other to arrive at a resolution, and eventually that decision was transmitted, and sitting in the Supreme Court where the litigation was pending, we could either accept the resolution or permit them to go back to the court. So that was the method which we had followed. This year we realized that it is not sufficient to just get in touch with the litigants or the persons whose cases are pending in the Supreme Court. It is also very, very important to have the discussion with the advocates who are having the cases here. So we involved all the lawyers who had filed cases before the Supreme Court on behalf of those clients. We had a detailed meeting with those lawyers. We also had a meeting with, if it were an institution against which the individuals had filed cases, we brought those lawyers appearing for the institutions. We also brought the management of that institution here. Like take for example a bank case. A person is filing a case against an insurance company. So the individual claiming insurance is before this court. We also have the advocate representing the insurance company here, and we also had officers belonging to the insurance company coming here. So all the three were there. The Honorable Chief Justice and other judges have addressed them and talked to them, saying that this is the process which has started here. While this segment of those representing the parties were present in the court, simultaneously NALSA was also contacting the clients at the grassroots level. Both were later on will integrate, and finally if a resolution is brought about, and that will be taken on board by us, and we will accept the resolution and we will pass an order on the basis of the resolution and the terms and conditions of the agreements that they have arrived at. So this is a process. It's a kind of an evolution, so to say, from what we were doing earlier, and this is much better an approach because lawyers are really the representatives of the parties. Without getting in touch with the lawyers and getting to know what their clients' aspirations are, we can't directly get in touch with the clients and then ask them to resolve. That's not the method. Over a period of time, perhaps if there will definitely be more such Lok Adalats to be held by us, perhaps it will be direct and straightforward, where we would ask the lawyers themselves to get in touch with their client and sit here along with us, the mediators, to get the disputes resolved here. That will be perhaps simpler, straightforward, and more easier for us to handle. If it were a simple case of an agreement between the parties, it's the conscience. If they are honest and if they are very clear about the benefit that they had arrived on the basis of the discussion, you don't really need an enforcing mechanism. But nevertheless, we had to evolve the alternative. In the event they followed thereafter, what is to be done? So the law has evolved, and that particular agreement that they arrive at is now given the sanctity of law, and that agreement will be in the nature of a decree of a court, which can really be enforced. So it is given the tenor of an enforceable document. So agreements which are arrived at on the basis of a mediation and in Lok Adalats are enforceable documents. so they can straight away be executed. So that much confidence people will now have that once I arrive at a settlement, this will be binding on all the parties. It's enforceable, so the person who is wanting it to be enforced and other person says that I will not abide by my agreement, will be bound by execution in a court of law. So you can, in the same manner as that of a judgment of a court, you can get this agreement enforced.
Talking about the cost, so if a litigant opts for such a process for settlement of their cases, do they have to bear any additional cost?
So far as the litigants are concerned, as of now, there is no cost at all. No cost on the litigant at all. Over and above that, if during the pendency of a case that parties are referred to a mediation and or through the process of Samadhan Samaroh or something like this or Lok Adalat, they arrive at a settlement, the costs that are incurred in the form of a court fees and stamp duty when the cases are filed, those are also returned back to the party. It's a kind of a very positive incentive to settle it rather than to litigate.
So speaking specifically about Samadhan Samaroh initiative, what are the timelines for this entire initiative, and can someone still join this process, or is that date over?
There is nothing so formal about it. Even every day, myself or many of my colleagues, the moment they come across a dispute presented before them, if they feel that it is resolvable through Samadhan Samaroh, they even refer the matter. There is no formality to it. We have been adding large number of cases which are pending here, either through an advocate on record referring to us or the court referring to us. Even on mention, we will say, let us put it up before the Samadhan Samaroh bench. So that's the positive part of it. The essence of this resolution is informality. That's the big distinction between a court cases and a resolution.
So if we're talking about the Legal Services Authorities Act, it provides for Lok Adalat. How does this initiative really build up on that mechanism?
This is no different from that. It's one and the same, except that the name has been changed. But so far as the process is concerned, and the Legal Services Act gives the legal regime under which the whole system operates. But then how is the resolution brought about? It's through the process of mediation. Now mediation, we have another statute. Substantial provisions have already come into force. So it is the process of mediation by which a resolution is brought about within the framework of Legal Services Authorities Act. These are the two acts which are in tandem and then work together.
So as you were mentioning earlier, special Lok Adalat was conducted earlier by the Supreme Court as well. What were the learnings? You mentioned one of those, but
yes.
Were there any other learnings which were there and which have been incorporated this time?
Yeah, actually you're right. It's a learning process, right? Every time you conduct, you will learn more. So we have learned it, but one important lesson that I would have learned is that there is necessity to institutionalize it. It can't be once in 2 years or once in 3 years or even once in a year, and you prepare a new team, put them in place, and then conduct this Lok Adalat and then forget about it. This is something which we need to have as a permanent setup. So we have already started that process. We're going to do it. We're going to institutionalize it, and the process will be continuous, and we'll be building upon it. This is a great lesson, and it's going to be better and what we call with institutional memory and institutional expertise and institutional plurality. With that experience, we're going to build it up. That's the big advantage that we have got.
Right. So building up on the experience of the last special Lok Adalat that was done, and now that the Samadhan Samaroh is being implemented, what are the challenges that have come up, especially now that you talk about institutionalizing this setup?
There are multiple challenges. I mean, the core of it is in the art of persuasion, right? Building up trust. So you need very good trained personalities who will enable people to walk towards resolution. Now, who are those personalities? Are we talking, if we are talking about mediators, are they independently trained and experienced mediators? So we don't have too many mediators which are exclusively professional mediators. So most of the lawyers have to double up. They are lawyers in a court, they can choose to be mediators. So therefore, the human resource that we have today is the resource which is about 80% a resource of lawyers themselves. So the biggest challenge is, if lawyers are to be mediators, they will have to train themselves, they will have to upgrade themselves, they will have to shed a great amount of techniques that they would have learnt as lawyers and relearn the techniques of mediators. So that's a challenge. It's time consuming. That binary and a distinction between the two lives, one as a lawyer, one as a mediator, has to be very clear, separated, and must develop it in such an extent that one doesn't overlap on the other. This is a big challenge. The second challenge I think we can meet is to create a permanent body and a continuous department in the Supreme Court, or some kind of a separate section where we'll have manpower who will continuously keep dealing with it. The third challenge is about domain expertise. It's very, very important to have mediators who have expertise in the subject. So I believe there is no area which can't be resolved through mediation, but it depends upon what is the expertise of the person who is bringing about the mediation. Even very highly technical contested topics like insolvency can be mediated very easily and effectively. Acquisition can anyway be mediated. Company matters, corporate matters, trademarks, these are all niche areas for lawyers' practice, but they are, according to me, much more easier to resolve through mediation than litigation.
What kind of cases are being taken up in Samadhan Samaroh?
A whole variety of cases are there. Land acquisition matters. We have matrimonial issues. We have cases where property declaration of ownership rights, injunction cases, and such are the civil matters. There are also commercial matters are also there. There are also large number of appeals relating to motor accidents claims. There could also be check bouncing cases. So there is no periphery for that, but substantial matters are of this nature.
How did you encourage people to adopt this method, to try mediation?
The mediators are really experts in the field, and the trained mediators, I have seen them. But the reality of the fact is that what is at stake is, number one, time. Number two is peace of mind. Number three is cost, expenses. So invariably court cases are long drawn. So therefore that is one factor which will persuade people. Secondly, they are also expensive. Third, very importantly, they are uncertain. You don't know where you're going to win or lose. By the end of 15 years, you don't know whether you have won the case or not. Even if the court says that you have succeeded in the matter, what's the use? You lost the time, you lost the money. So these are the things which on being properly informed, and the people calmly sit down and realize that emotion apart, anger apart, disillusion apart, where am I going to be by the end of the day after the case is over? They would be persuaded to adopt something like a resolution through mediation.
Samadhan Samaroh started on 21st April. It's been almost 4 months now. So how do you see the progress of the initiative and the response to it?
As I told you that this is a process. We keep improving from time to time. We had large number of, Honorable Chief Justice has held a number of meetings with the Chief Justice of every state, the Advocates General of every state, and also the district judges and also the officers who were involved in acquisition, and then the state representatives like the chief secretaries and other things. This time it had been a process which involved consultation and prodding of many of the stakeholders. So that process is a long drawn process, and it was professionally conducted continuously with great amount of enthusiasm and sincerity. I think that's a very positive thing.
And have you seen any kind of cases or any states or any patterns where there has been a very positive response?
Yeah, 1 or 2 states have done a very a good job. It will again vary from state to state, high court to high court. It's very, very varied. I mean, we can't have, there's no standard. So it depends upon multiple things. So subject wise, interestingly, large number of tax related resolutions have also come forward this time, because that was because of a positive input from the finance ministry. They were also very keen that a number of tax related matter could be resolved. So those had come. Some number of some cases, they themselves came forward and said that we will not pursue these cases. So there were others which they thought we will leave it to the court. So I think that's a very positive thing. And these things, we have got a flicker of all this. We're going to build on this and improve on this the next time.
So as Samadhan Samaroh is coming to its conclusion very soon, how would you want to judge the success of this initiative? Will it be that one number of the as to how many cases have been settled, or is it more nuanced?
Personally, I will judge it from the perspective of how well we have formulated our institutional mechanism for mediation in times to come. I will look at it as a stepping stone. It's not in numbers, it's not in saying how many we resolved this year in comparison to the last year. It's a continuous process, and it must be very closely associated with the working of the court, and we can definitely, that's positive part of it, definitely we can do much better in times to come.
Right.
That's the positive part.
Mm-hmm. So in a sense, you see this Samadhan Samaroh initiative from a long-term perspective, from a broader perspective,
Yes.
wherein each special Lok Adalat has added to the experience, and going forward you see it something that will be institutionalized, and this process of mediation will be strengthened.
Yeah, that is the essence of it. If we don't convert this into an institutional memory, then we would have lost it. The real thing will be dependent on how we have converted this into a institution in times to come. If we do that and set down, I keep telling these officers that as you keep performing your functions, note from time to time the difficulties that you have encountered, and by the end of it, if you put them down and formulate the whole process in the form of the steps that have been taken, this will be of great help for the next Lok Adalat to be conducted. Step by step we will improve. That is how institutions are always built.
All right. We can think of Samadhan Samaroh as a step towards building an institution where mediation would be a strong aspect, a key aspect of resolving matters. Thank you very much, sir, for giving us an overview about Samadhan Samaroh and giving us time and telling the listeners of Akashvani the details about it. Thank you.
Thank you so much. Thank you.
Thank you.